Hey, how's it going? Let me turn this music down just a little bit and we can get cracking on today's topic. Um, Welcome to the Strategic CLO. With me, I'm your host, Noel Bagwell. I'm still pretty new to doing the Strategic CLO. I had been doing some group coaching in this space, but I decided to convert the format of this particular work to a podcast just because of the timing that I usually have for going live and doing the streams. It just seemed like a better fit to do this as a podcast than to try to continue to do it as group coaching. So, and there were some other factors as well. I don't want to bore you to death with that. I want to jump right into a topic that I'm really excited about, which it's hard to express because there are going to be some people who really love this and embrace it, and other people who are extremely resistant to it in my industry. I feel like a bit of a black sheep, and I'm not complaining about that. I just feel like a bit of a black sheep, honestly, in the legal profession, because for a long time, I have been uh, vociferously opposed to the billable hour. I'm less opposed to it now than I used to be. I do understand that it has a place and that it's necessary in certain contexts to use the billable hour. And let me get rid of this so we can have a more intimate. It's just like in the way, like all these tools. Um, I understand that the billable hour has a place, and I'm not as radically opposed to it as once I was. But I do think that by and large, my old stance on the billable hour is still the correct one. And my old stance was that the billable hour has a lot of perverse incentives built into it. I mean, just think about it. If someone hires an attorney at $500 an hour and pays them a $10,000 retainer, you're talking about 20 hours worth of work for $10,000. And let's just assume that the attorney is really worth that and it's great. That's not the issue. The issue isn't like, oh my God, that's a huge hourly rate. That's not the problem, because some attorneys are worth that. And honestly, that's not an outrageous rate anymore in 2024. $500 an hour isn't, depending on the kind of work you're doing, it's not an outrageous rate. I know partners in big law firms that are charging more than $1,000 an hour. So it's not crazy, right? Um, that's not the issue. The issue is there's no accountability really. How do you know that they spend the amount of time that they say they spend on your matter and doing work for you? How do you know that if they bill you for 2 hours of legal research that they didn't just do an hour and a half or 45 minutes? How do you know? It's the honor system. And so there is among unscrupulous attorneys an incentive, at least. I'm not saying that it happens. It's hard to imagine that it doesn't happen, but there's an incentive at least to overbill, by billing too many hours. And that's bad and that's wrong. And clients are afraid of that, and rightfully so. It's understandable that they would be afraid of that. And there's not really a whole lot that can be done about it. I mean, it's hard to catch a lawyer doing something like that. And usually when you do, they say, oh, it's just a clerical error. It's just a mistake. Here, let me just adjust that down for you. I'll credit you that back or whatever. They will do what it takes to avoid a fee dispute. And they should. That's good. But there's no real accountability for that kind of thing. It would take another lawyer in the firm, calling them out, catching them out, and then going through like firm policies. Like if it's a solo attorney, there's no accountability at all for that. So that's a problem. But honestly, that's not even the biggest problem with the billable hour. The biggest problem is that it makes your client feel like they're in a cab with the meter running, that every single time they talk to you, it's just the sound of a cash register in the back of someone's mind going cha-ching, cha-ching, cha-ching. It's usually the client's mind, right? The lawyer's trying to focus on the legal work, but the client is often distracted by, oh my God, this phone call is costing me, this phone call is costing me $100 for 12 minutes. Like it's just, or whatever, right? They're doing the math and they can't stop. They're so distracted. They're not fully engaged in the call. And because they feel that way, they're unwilling to call the lawyer in advance of there being a problem in the client's estimation. What I mean by that is the client will wait until the client feels that there's a problem, and then they'll call the lawyer. They don't call the lawyer early and often to involve them in like regular operations and regular decision making, the strategic decisions around starting a business, running the business, selling the business, whatever. And this is just in a business context. It's also true in other contexts of practice. I'm a business lawyer, but it's equally true. Like if you had a subscription-based family law service, I heard of one in Southern California. Apparently, there's a lady there who's doing subscription-based legal for family law in Southern California. I would love to meet her, talk to her, know more about that, have her as a guest on this program. So whoever you are, if you see this and you reach out to me, I've only heard rumors of your existence and have not verified them, but I would love to know more about that. But just say you had an attorney like that, and then you had some issue with, child custody or business succession planning or, some sort of, other family law matter, right? You had some issue and you could just pick up the phone and call that person, talk to them, or email them, or text them, or send a message through their client portal, or whatever it is, whatever the communication mode is, right? So you could just do that, get your question answered, and not have to worry, get the counsel, not have to worry that you're going to be billed for every minute of the time spent, because you're just paying a monthly subscription fee, and all the strategic legal advice that you're getting is baked into the cake. It's unlimited. There's no additional charge for that. What if you could do that? How liberating would that be? How much more would you use that lawyer's services? Humorously, you could think about it in a criminal law context. I hope nobody. I know there are recidivist criminals that are just sort of like in and out of the revolving door of the justice system. I know that, but it probably would be an equally perverse incentive for a criminal defense attorney to have a subscription-based legal service. Maybe you could. That wouldn't be ideal, I think, for anybody. It's funny to think about, but it's almost like borderline, like Better Call Saul kind of thinking. I think, in a wills, trust, and estates context, especially when you're dealing with, like trust management, or something like that, a subscription-based model could work. There are lots of different ways that subscription-based legal services can solve this problem of, the retainer and billable hour by offering a discrete package of legal services for a flat monthly fee. And I think it's important as a profession that we look at alternative fee arrangements, alternative fee agreements, and stop relying so much on the billable hour. I have pioneered that. I have championed that for the last decade in my practice. And I'm proud to now be the director of subscription legal services for Industria Business Lawyers, IBL. And I'm also the practice group lead for our fractional chief legal officer service. I basically took the profit from legal service that I developed under my own brand, Counsel and Clarity, and which is there, Counsel and Clarity. I took my own IP and I brought it over to IBL, and we are working on deploying that under the IBL brand, training up other attorneys to do what I do the way that I do it for growth stage companies. And I want to talk a bit about that. The big problem, I think, for people generally, not just businesses, like I have a grander vision for subscription legal services across the legal industry, right? Across all, many, maybe not all practice areas, looking at you, criminal defense, right? Maybe not all practice areas, but there are a lot of practice areas in the law where subscription-based legal services could be a game changer, because it would allow clients to have the confidence to reach out to their attorney, engage with that attorney on a more regular basis, like early and often, and get preventive legal insights when they need them, before there's something that's so on fire that you then realize, oh man, I really have to call a lawyer. Because by that point, it's I'm not going to say it's too late, but it's too late to prevent the problem, which is the cheapest thing to do. The cheapest thing to do when it comes to legal issues is to prevent there from being a problem in the first place. The more expensive option always is to wait for there to be a problem and then try to fix it. So what we want to do is and part of the reason for that is that the subscription-based model, the way that it's billed, it allows you to budget for it, right? When you have to hire an attorney on the retainer and hourly model, you either keep the lawyer on retainer and you just sort of try in your best estimation to forecast how many hours you're going to need every month with that lawyer. And then you do some math and you come out to, okay, well, we need about this much in the budget. But then you get mad at your lawyer for either, like being over budget because things took longer than expected, or, you get mad at yourself for not budgeting enough, or whatever it is, right? It's just, it's a lot of forecasting, and it's a lot of having to calculate how many hours are going to be required to do things, which doesn't really have a direct relationship to the value that the lawyer presents. There are things that I've done for clients that haven't taken very long, but have saved them an enormous amount of money. I remember one client not very many years ago who was approaching a transaction. They had not engaged in the transaction. They hadn't done anything really yet. They hadn't like signed contracts and accepted money or anything like that. But they'd been talking about a transaction with some other people, with some other individuals, and they reached out to me because they basically negotiated everything and had reached a decision internally that this is what they wanted to do. And then they reached out to me to basically just be the document monkey, to just draft the contract. And I said, no, I'm not going to do that. And they were like, why not? You're our lawyer, right? We have, at that time I was branding this as outside general counsel service, which is a different thing. And I'll get to that in a little bit. But this was, outside general counsel service, and it was, unlimited, flat monthly fee, the whole thing. I've tried doing what I do various different ways. I've experimented with it, and I've seen what works and what doesn't over the last, like I said, decade or so. Since 11 years now, since 2013. Anyway, I told the client, I was like, yeah, I'm not going to do that. And they were like, why not? And I said, oh, because if you do what you're talking about doing, the way you're talking about doing it, that transaction is not just voidable. Like, you couldn't just go to court and have it undone, but it's void as if it never happened. It's just not a transaction that you can legally do. Like, you can't do this. It would violate all these regulations. And just no. If they had proceeded with the transaction, it would have, the amount of money involved was about $50,000. So it wasn't a huge amount of money, but it was big to them. It was enough to, to move the needle, to register, and to get some stuff done for them. So, 50 grand. But I was just like, no. And I explained to them why, and then I explained to them what they needed to do next, and, how to accomplish the goal they were looking for in the right way. And I said, it's too bad you didn't involve me sooner, because now you're under the gun. You want this money, for this transaction. You want to do all of this stuff, and you feel like you don't have a whole lot of time because you waited so long to involve me. If you had just involved me early, like in the planning phases of this, you wouldn't feel the pressure, this crunch of time, and all of this stuff. So, next time, maybe just involve me sooner. Talk to me sooner. After all, you are paying a flat monthly fee. Don't stop thinking like I'm on retainer and hourly, right? Like, use the resource, it's there. And I've found consistently that that's kind of the biggest challenge with subscription-based legal support for most people, is they're still thinking, oh, this lawyer's on retainer, and they have the old mindset. You almost have to retrain the client how to use the service to get the most out of it. But the power of it is phenomenal. I think over that client's entire like lifetime value to our firm, it wasn't more than $20,000. It wasn't more than $20,000 lifetime value, I don't think, for that client. But that weekend I saved them $50,000 from engaging in a transaction that would have been been subject to rescission. It would have been void ab initio from the very beginning, as if it never happened. They would have had to give the money back. Not to mention the regulatory fines and like all the consequences that would have flowed. When I say I saved them $50,000, I just mean on the nominal $50,000 of not making a $50,000 mistake, much less all the consequences that would have happened. Could have been double that easily, right? So the value is there. I think over that client's entire lifetime, we tend to send an ROI report at the end of a client engagement, if that's easy to do and warranted, and it often is, or if the client requests it, or if we just have a little extra time to put it together. I try to do that. I try to make the effort to send an ROI report to clients at the end of the engagement, and I think I sent him an ROI report that said that we'd saved him over $70,000. So the ROI is there. I mean, almost 4 to 1. It was like 3.5 to 1 ROI for him, benefit versus cost. And if you're getting back, triple the benefit versus the cost, I mean, it's a no-brainer. It's definitely profitable. That's why we call the service profit from legal. It does what it says on the tin. If you engage with it, if you use it, if you do what it, if you do your bit, I do my bit, then it's a profitable relationship. But also, because of the way that it's billed, because you're not billed retainer and hourly, you can budget for it. If it's a flat subscription fee every month, you don't have to guess how many hours are going to be spent on the matter like you would, like we were talking about, like I was talking about before. You don't have to guess anymore about how many hours are going to be required because it just simply doesn't matter. The billable hour no longer factors in. It's not even part of the pricing. It's not part of the equation for the value-based fee that we charge. So we don't think in terms of billable hour anymore. We think in terms of how much value can I provide to the client? What's the next most comparable thing? Like if they were going to hire us as a full-time employee, what would that cost them? What can we do that's cheaper, that's going to deliver high ROI? That's the way we think. So in terms of pricing, so because you can know that I'm paying like $9,500 a month for fractional chief legal officer service, far less expensive than hiring a chief legal officer in your business, by the way, about a third of the cost. Because you're paying that $9,500 a month, you just put that into your budget, and then you know how, if you need to adjust the prices for goods and services in your business, you just know what that cost is going to be. And you pass that cost along with all the other costs of running your business. You pass that on to consumers in the form of prices for goods and services. And for a growth stage company that's making, $10 to $25 million even or more, per year, that's not an unreasonable line item in your budget. The average cost of a chief legal officer is about $350,000 a year total compensation. And that's obviously that's an average. So you have a range of like 275 to 425, somewhere in there. And your average is about $350,000 a year total compensation for a chief legal officer, nationwide average. So we're talking about spending a third of that on a part-time or fractional chief legal officer. You spend a third of that. That leaves the other 2/3. I'm not saying you should dramatically change your legal spend, although you could, if that service alone was meeting your needs, you could. But our recommendation at IBL is that you spend the other 2/3 of your budget on legal implementation, because the fractional CLO is there to provide you with strategic legal advisory services. So, what I want to talk to you about for the remainder of this video is this distinction. Like, I wanted first to talk about the billable hour, right? That's something that I haven't really, I feel like you almost have to have the conversation around the billable hour and how it's billed and how much money are we really talking about, and is that reasonable? You kind of have to have that conversation on the front end. But my experience has shown that this is profitable for growth stage companies that really work the process. It is a profitable thing, and it is a reasonably priced thing. And it does leave you about 2/3 of your legal spend to focus on doing things like, the implementation of strategic legal advice, the drafting of the contracts, reviewing of the regulations, to, like all these different rubber meets the road kind of functional legal implementation things. So we leave you the lion's share of your legal budget. Even if your legal budget was, we only have enough in the budget for just one guy, like a chief legal officer. Well, instead of hiring that guy and putting him on your payroll, you should make your money go farther by hiring a fractional CLO who does the strategic legal advisory work. And then, you can hire a very good team to support him with legal implementation services. All the functional stuff. And for that other 2/3 of your budget, you can get a paralegal, an associate or two. You can get several like contract attorneys and people who are, put together in an organized and cohesive fashion as a team underneath that fractional CLO. So your money just goes farther. More brains are better, right? That's the theory. So, and it works in practice as well. So it's good to kind of talk about this, but when you get past the conversation about money, you get past the conversation about, oh my gosh, is this affordable? And why do I need this? Like, why can't I just wait until I think I need a lawyer? Why can't I wait till my hair's on fire and then hire a lawyer? Once you get past like, okay, that's a terrible decision, don't do that. Have the lawyer involved early so that you can have the lowest cost option generally, which is prevention. And to do things right the first time, measure twice, cut once. So do that. And then also, here's why it's affordable. And yes, financing is available and stuff like that. And once you get past the conversation around money and whether or not it's a necessity, then we have an even more interesting conversation. And that's what I want to focus on for the rest of today's podcast episode. So this is kind of part two, right? Part one, we might categorize and call, the need and the cost of fractional CLO. But now I really want to talk about use cases, because the conversation then becomes around, oh, like, okay, well, let's just assume, or I'll stipulate to the fact that, yes, I have a need and prevention would be better. You're right. Better not to wait till my hair's on fire. And also I'll stipulate to the fact that, yeah, we're a growth stage company. So yes, we do have $350,000 for legal in the budget because we're smart enough to budget for legal. But why would we use a fractional CLO service versus just hiring that CLO guy and maybe paying him less, or trying to do something else, right? Like why fractional CLO? Why not full-time CLO? Like, shouldn't we control this? If it's this important to build a legal department, shouldn't we have it all in-house? And I've put together a few slides because I think it makes it easier to see, to talk about, our profit from legal fractional chief legal officer system, the support for growth stage companies that we've put in place. And so I'm just going to talk about this for a little bit. I designed profit from legal, I should say. I designed profit from legal for growth stage companies because I wanted to have four specific effects, four specific benefits. I wanted to make the client company more profitable, more stable, more efficient, and ultimately more valuable. Like, if you're trying to exit, you want to sell your company at some point, or if you just want, better financing terms for access to capital, for operational financing or whatever, it helps to have a higher valuation in your business. Certainly, if you're trying to exit, you want to exit for maximum bang for your buck. You want to get paid for all the blood, sweat, and tears that you've poured into the company as you built it. All your stakeholders and investors, they likewise want to maximize the return on their investment. So improving your valuation is a big deal, and value follows assets, the creation of assets in your business. You have to have something beyond just the knowledge that's stuck between your ears that is valuable to sell. So our legal expertise and the strategic legal advice that we provide, it helps our growth stage client companies to identify, streamline, and capitalize on the opportunities to grow and expand, to build these assets, to mitigate risk, to navigate the sometimes very complex regulatory landscape they have to deal with, and to even raise their business valuation. And in doing these things, as we go through the functional process of analyzing their business, comparing what rule, like looking at all the rules they have to play by, and then analyzing how to apply those to their operations and to really align legal support with their business goals, right? As we do that, there naturally arises an opportunity to improve efficiency. To, like, we'll look at something that they're doing and we'll go, well, why is this way? And they'll say, oh, it's because such and such, or it used to be. You often hear that. Well, it used to be that, this is what would happen. Well, is it still that way? No. Have you changed? Have you updated the process? No, we really should. Okay. That's an opportunity to take a second look at the way things are being done, the way things have been done, the way things ought to be done, and to harmonize, improve the efficiency there. A lot of times efficiency diminishes over time naturally because you implement a static system in a dynamic situation. And so it just naturally gets outdated. The way that things are now aren't the way they used to be, but you're using a process designed for the way things used to be. And that's not efficient. So Our service really does improve efficiency, lower risk, and generate new opportunities for growth and profitability. So we want to make sure that we're dealing with the right client too. It's a huge range, by the way, for what is a growth stage company. Like, what does that mean? Who are our clients really? Um, I've seen estimates from 10 to $100 million in revenue, or 100 to 500 employees. That's a huge range, and I think it's too broad. I think really the ideal client, when you're looking at, profit from legal, and the ideal client profile, is a business that has probably 15 to 25 million in revenue. I'm talking about the center of the bullseye for our customer base. So obviously we can serve clients that are 10 to 100 million in revenue, 100 to 500 employees very easily, and you can even scale it up or down outside of that range. But, you know, in terms of what is at the middle of the bullseye, you're talking about probably 15 to 25 million dollars in revenue. Because companies within this range are likely experiencing rapid growth, and complexity in their operations is increasing, but the companies may not, of that size, may not yet have the full spectrum of in-house legal capabilities to navigate their emerging challenges effectively. So that's just sort of a good guidance and rationale, right? They probably have 75 to 100 employees actually, so they're on the lower end of this employee range size that is typically given for growth stage companies, that I think is too big. At the size of a 75 to 100 employees, the company is large enough to face significant legal, regulatory, and compliance challenges. But again, they may not have the dedicated in-house legal team or even a chief legal officer. They might have general counsel, they might have a lawyer they've had a relationship with for years, that it's like the on again, off again boyfriend or girlfriend, right? Like, you just kind of sometimes date them when you need them or see you want to see them or whatever, but they're not really, you're not married to them. So it's kind of like that. This size of 75 to 100 employees indicates that the company is scaling and can scale up and down, but it still values its agility and its strategic reliance on external partnerships, because that's typically how you get there, right? Um, Probably our ideal, like at IBL specifically, our ideal client may be a software as a service company. It's a dynamic and fast-paced industry. There are lots of legal issues relating to intellectual property and data privacy. There's lots of contracts work and regulatory compliance stuff. So, and then they have very rapid innovation cycles, and typically do business on a global scale in a global market. So that both magnifies the challenges and risks, but also the rewards. So SaaS companies are uniquely well suited, I think, to using this profit from legal service, but by no means are they the only ones. There are lots of industries, I would say virtually every industry, to benefit from this, but probably the ones that benefit the most are the highly regulated industries. So technology, healthcare, finance, manufacturing, where you do have a lot of regulatory compliance, and that's a significant concern, and where strategic legal guidance can provide substantial value. And then you've got, your high innovation and intellectual property IP intensive sectors, like, again, technology, software, biotech, creative industries that require, ongoing IP management, protection, and strategic planning. I'd say they're the top picks for people who are going to get the most out of this. But there really is not a particular industry that this is made for. And profit from legal, as you'll see as we take a closer look at the individual use cases, can benefit businesses in any industry. So how would you use a CLO? How would you use a fractional CLO? Lots of lots of my clients, lots of them are like, well, what would you do for me? And this goes back to the difference between the mindset of I'll call you when I realize I need you, and okay, I understand in theory the proposition that prevention is better than trying to, remedy a harm that's already befallen the company. I understand that in principle, and I accept that. And I also accept that it's better to budget for legal services and pay for them as, in chunks over time, instead of paying trading time for dollars in a really big, like bursty lump sum. I have to pay, big retainer all at once kind of way. So it's easier on cash flow, it's easier to budget. I accept all these principles. So I accept the preventive law proposition, and I accept the regular maintenance of the relationship. But that still doesn't tell me anything about what you would actually do for me. For a growth stage company that's got 15 to 25 million in revenue, like we've talked about, and let's just say it's a SaaS company. We don't have to a SaaS company, or you know, a technology, another kind of technology company, or a healthcare, or finance, or manufacturing company, whatever kind it is, right? Let's just say they need a CLO for the first time. They might have a general counsel attorney, an outside general counsel, or something else, and that's fine, but that's not a chief legal officer. There is a meaningful difference. And a lot of people, I've had this conversation too with legal professionals, and they say, you're making a distinction without a difference. I respectfully disagree. I think the difference between a general counsel attorney and a chief legal officer or fractional chief legal officer is the emphasis that you place on the kind of work that you do. Both attorneys can do the kinds of work that the other do, right? Like a CLO can do the kinds of work that a general counsel does. General counsel can do the kinds of work that a CLO does, but they tend to have different focus. The general counsel tends to focus more on implementation, like functional, get your hands dirty. I'm going to draft that contract. I'm going to negotiate this deal. I'm going to, you know, do the regulatory compliance research and report to the CFO or the CEO, right? They're going to do all of that kind of work, and they're going to make sure in a very functional way that stuff gets done, because that's where their focus is. The CLO, on the other hand, has a more strategic focus. It's strategic legal advisory work. And what a lot of clients fail to understand or fully appreciate, business clients uh, fail to understand or fully appreciate, is that you actually need both. Even though a general counsel can do the kind of work a CLO does, they have to think differently. They have to shift their focus. You can't really focus on a whole bunch of different stuff at the same time and maintain the clarity of your focus and the effectiveness of your work and your role. You can't. You people who focus on one thing obsessively tend to do it, I think, a little better generally. Where you get the very best results in a situation is where you have a chorus of those people advising an ultimate decision maker. We see this even in the development of AI. We see the development of what are called agent swarms. Swarms of highly specialized artificial intelligence tools, each agent being developed to do one task really, really well, and having sort of one master algorithm or overseer AI that queries and listens to each of those specialists. So you have a chorus of agents that are all informing the sort of bigger brain, the decision maker algorithm, right? The central one that unifies them together. And it has its own algorithm about how to balance and weight all those inputs. What's beautiful and wonderful, I think, about artificial intelligence is it gives us an opportunity to reflect on the best way for us to make decisions too. And we do that. And we should, at least as decision makers, we should be doing that more, I think. We should be having more of a chorus of voices. And when you look at the corporate hierarchy and the ladder, the power ladder, right, for a corporation, it's often, you have the shareholders and they're kind of removed from everything. Yes, they get to elect people or nominate people to the board of directors or whatever usually. Then you have this board of directors. And that's kind of like we're going to corporately, as a corporate body, make decisions about the general strategic direction of the company. But then you have the officers, CEO, COO, CFO, CCO, CTO, CIO. It's just endless. CLO. You have all of this chorus of voices, and their job is to govern the strategy for each individual division of the company or the company as a whole. The CEO is the chief executive. He's in charge of making sure everything happens. Chief operations officer is in charge of making sure that all the how and the logistics and the functional parts of everything, they're all clicking and working. He's your efficiency guy and effectiveness guy. CFO manages the money. CLO makes sure that you're not getting into legal trouble, doing the forecasting. So it's strategic. The CEO shouldn't be expected to come up with the budget, the legal strategy, the marketing strategy, the operational strategy. That's not his job. The CEO's job is not to come up with and control and micromanage the strategies for every part of the business. For the legal department or the legal function in the business, the CLO's job is to come up with the legal strategy for the business. That means he has to understand and have a dialogue with those other division heads, those other department heads, human resources, operations, finance, and IT, all of it. He has to be able to have clear, open communication with all of them and understand enough about them to do his job right, which is to develop a legal strategy that if the CEO listens to it, adopts it, and executes on it properly, will keep the company safe from legal liabilities and help it to grow and be more efficient and more valuable, etc. A general counsel attorney could do that, but largely general counsel attorneys are hired to be generalists. They just do a little bit of everything. They're not hyper specialized. They're not even specialized in developing legal strategies. They are generalists that do a little bit of strategy and a whole lot of execution on the strategy. So that's the philosophical difference, but also the functional difference. So if you're going to hire your first CLO, I think you should make it a fractional CLO to leave enough room in your budget to hire either a general counsel attorney or some other legal implementation staff. Could be a contract attorney or several contract attorneys on an as needed basis. It could be, a paralegal. It could be some combination of those. But hiring a fractional CLO gives you what you need in terms of strategy and legal operations support and guidance, right, to develop these things for the first time in a growth stage company, in order to optimize legal spend, right, to balance the high impact strategy with the routine legal tasks that are efficiently handled by legal support staff, which could include your existing general counsel lawyer, by the way. No reason to fire that guy. We're not talking about either or. This is both and. And then you're ensuring with this hire comprehensive and cost-effective legal oversight. So what would it look like if you've got the foundation of a legal department built on your first hire being a fractional CLO? Well, the status quo is that you probably have never had even your own general counsel attorney, or you may have engaged an outside general counsel attorney. But in any case, you're trying now as a growth stage company to build a legal department. And chief legal officers are expensive. Spending the idea of spending $350,000 on average total cost to hire one person may not be super appealing to you. That's very understandable. So you can have a more cost-effective and solution that still provides you with a powerful foundation. This fractional CLO will provide strategic legal advisory services. They will do systems design work. As I said, growth follows the creation of assets. That includes systems and processes that move your business forward when they're properly executed. It's unreasonable to expect the CLO to do all the execution as well, because their focus is on systems design and strategy. But they also do help to align legal support with all the other operations of your business. So they are well integrated into your leadership team. They talk to everybody else, and they align your legal support with your business goals. We help you get the balance of how to do that right. This is the first use case. It is not the only one. In fact, the next one is somewhat similar to it. You may need a legal strategy guide for your CLO. Let's say that you've already hired a CLO, but your CLO is very technically focused. Maybe they used to be a general counsel attorney, but they've been hired into this CLO role. And you've found, since they were given the title and the authority and the responsibility of being the chief legal officer in the company, they're really good at the technical aspects of doing what they do, but they're actually not great at formulating big picture strategic legal insights. We can help to bolster that with better strategic legal support and legal operations. This will enhance and elevate the company's overall legal strategy, which has a ripple effect down through all the technical layers to improving growth. So, this is really expert advice, and it's designed to work with your existing chief legal officer or your existing general counsel. Sometimes when we're doing work like this, we've got a CLO that was hired to be CLO because they are a specialist in a unique area, like software as a service or cryptocurrency or global market expansion. They're dealing with like navigating complex international regulatory environments and stuff like that for either manufacturing or what have you. So you kind of need the big picture legal strategy Sherpa to interface with this highly intelligent technical specialist, that you've hired to be your CLO, because they're kind of like a super GC. They're like a super general counsel. They're in the role of CLO, but actually they're just, and I don't want to say just a general counsel, they're actually more like a general counsel who's been overloaded with too much strategic responsibility. They're actually better placed as a middle person between, sort of academic, ivory tower seeming, but actually in reality very functional strategy and the execution. That person who is the super GC is a bridge between the purely functional implementation of legal strategy and the formulation of big picture legal strategy. They are like legal strategy specialists and they're really good at designing strategies in one specific or several confined contexts. They're not great at the really big picture, So, bringing in a fractional CLO to help with the really big picture stuff so that this person can make the most of their own specialized knowledge, their own individual expertise and work history and all of that. Again, not taking anything off of them. Like if they were hired to be the CLO, let them be the CLO. There's nothing wrong with having a fractional CLO to support your CLO. You could call them like an assistant or a VP or whatever. The emphasis here is not on title, and it's not even on authority. It's on focus and the scope of your work and what you're trying to get done. And IP strategies are often something that benefit from this quite a lot. So if you're in an IP heavy industry and you've got a CLO, they probably have a really great history and track record of managing trademarks, patents, copyrights, that sort of thing. and they're great at developing like the strategy for that, for example, or crypto, if it's a crypto company or something like that. IBL historically was I think they were originally called International Blockchain Legal, and we've rebranded, right? Kept the initials, but rebranded. And my understanding, just from talking to my partners, is that crypto guys are really, really great at crypto, and they are capable of doing so much more, but they don't often have the bandwidth to do more. So your IP protection is enhanced when the people who are really great at doing that can focus on that, whether it's crypto, or whether it's IP, or whether it's some other area. It doesn't have to be those things. It could just, those are just good kind of examples, right? When you let someone do what they're best at doing, and you free them up, and you don't overburden them with too much big picture strategic legal work, then everybody benefits. The company benefits, they're better in their role, and the company can still have its needs met cost effectively. And the same goes for compliance strategy. People who are regulatory compliance specialists, they're really, really great at doing that. But asking them to do that and develop the big picture legal strategy for the whole company might overwhelm them. And so a fractional CLO can come in and be a legal strategy Sherpa. On the flip side, maybe you hire a CLO who's really great at strategy, but they're not good at doing those middle bits. The middle bits between big picture strategy and implementation. They're great at formulating a vision, but not building a prototype, much less building the production line model of whatever it is that you're building. So if you have a highly strategic visionary type CLO that has trouble merging the strategic legal strategy with like implementation and coaching and the practical application of all of that, then you may need someone to facilitate, to go between. I don't want to stereotype, but often this comes down to personality. It's not just about capability, although it is about capability, but it's not just about capability. A lot of times it's personality. The stereotypical INTJ, like mastermind, like INTJ being on the Myers-Briggs, right? Personality type, someone who is introverted, they're a thinker, not a feeler. They're a judger, not a perceiver, right? The INTJ type is seen as like an architect or a mastermind, but a lot of times on like funny personality tests, they are borderline evil. There's no personality type that is evil, but they're stereotyped that way. People don't often immediately trust INTJ people, but INTJ people are brilliant strategists, mastermind type, architect type people, but they do tend to be introverted. They keep their own counsel. They're not extroverted. They're not gregarious and outgoing and friendly always. They may be when they feel comfortable and, in a smaller setting, whatever, but they don't thrive on being the center of attention. They like to quietly, intuitively, and thoughtfully analyze things, make judgments about them, and they really are best when you listen to what they've carefully formulated and then implement that. They respond very, very well to that. They like to be seen as the puzzle solvers, the problem solvers. And I think that INTJ or sometimes ENTJ personality type is extremely common in this role, in the CLO role. I'm not saying it's the only one that's compatible or it's the right one or anything like that. I'm just saying highly strategic CLOs, they do tend to have that personality type, or one that's not too far off from it. So if someone is difficult for the rest of your team to relate to or get along with because of difference in personality, what you might need is a bridge. You might need a legal implementation coach for your CLO. They take the strategy and then they consult about how to implement the strategy. So you have the strategy, and then you have the implementation strategy for the strategy. I know that sounds super meta and maybe a little redundant. Like, well, why don't you just put the implementation into the original like legal strategy? You should. That's part of it. But what I'm saying is sometimes the person who's really great at developing the big, large scale strategy, legal strategy for the company, isn't great at designing the implementation. Because one is about formulating a vision, the next is about thinking about that vision in very practical terms, creating effectively a prototype. And then between prototype and production, there's going to be tweaks and changes and modifications. And sometimes the visionary is not okay with that. Sometimes they have trouble accepting that, rather. Some they can get okay with it. I'm not saying they're never okay with it. I'm just saying that a lot of times, people, they say, well, I accept this because I have to, but this doesn't really conform to my vision for whatever. And so they kind of chaps their ass a little bit. All right. So what would this actually look like if you had the legal implementation coach for your CLO? What's it going to do for you? It's going to make the implementation of your strategies a lot easier. Why didn't you just say that, Noel? And now I am. It'll make the implementation easier. It's going to integrate theory and practice more seamlessly, and it's going to streamline operations. But here's the other thing that's not on the slide that's really magical. It's going to create feedback loops. If you do this right, I think the real magic of this is feedback loops. A lot of times, because of the corporate hierarchy, because of differences in role and authority, it's very difficult for people underneath a direct report to honestly, candidly, accurately give feedback about the way a strategy is being implemented, because the strategist takes it personally if things aren't implemented perfectly or there's criticism about it. And they don't really want to hear excuses. From their perspective, it's this is the strategy. It's simple. What don't you understand about this? From the direct reports perspective, it's like, wow, that's a really high expectation, and you don't really understand the practical reality of taking your vision as I understand it and implementing it. And by the way, I'm not really sure I fully understand it. Having someone in the middle to grease the wheels is a very, very valuable thing. It can facilitate feedback up and down. You can translate between the sort of language that operations speaks and the language that legal speaks. And so you have this coach that's there to lubricate the mechanism between strategy and implementation. So very, very valuable thing. You may also have a very well-staffed legal department already. If you already have $25 to $100 million in revenue, you have 100 to 300 or even 500 employees, right? You're on the upper end of the range. Your CLO almost certainly has a lot to do and probably not enough resources to get it all done. Time, money, whatever. I mean, money may be less of an issue, but time, certainly time and focus are your two biggest resources. Even if you're not billing by the hour, time does matter. So a well-staffed legal department might gain a lot of value from an assistant CLO. And remember, the cost of a fractional CLO is only about a third of the cost of a CLO. So, they're not getting paid anywhere near as much as the boss, but they're still able to introduce fresh perspectives, enhance the strategic depth, help out, facilitate with all the things that the CLO can do, kind of just be an extra set of hands, someone who's a peer, in terms of skill and intelligence and capability, but, clearly beneath the CLO in the hierarchy. They're not directly the same. They're not on the same level. They're on the same level in terms of intelligence and skill and often experience, but they do report to the CLO as an assistant, and their job there is to support, like Alfred to Batman, to be the advisor to the king, right? You're there to whisper into the ear, to not be the face of the department, not be in control, but to be the strong right hand of the person who is, to be the Dick Cheney to your George Bush or whatever, right? However you want to think about it. So this service really enhances existing legal operations. It fosters innovation and strategic alignment, and it also, because this person's an independent contractor, you know, they have a contractual relationship with the company, and everyone has agreed to use this service for a specific time and in a specific way. And during the term of that contract, um, that person can't really be fired except for cause. So they're not worried about losing their job if they're candid with their boss. Obviously, getting the contract canceled or not renewed or something is still a concern. But at the end of that contractual relationship, there's an ROI report. So, if you're looking at the relationship by the numbers, you might say, hey, listen, you may not like what I said to you on that Thursday in April, and it may have, soured the relationship and you may not like me, but look at all the results that I've got for you. And I said that back then because I cared about you. I knew it was going to ruffle your feathers. I tried to be tactful and delicate, but you needed to hear that. And hopefully we can both look at this ROI report and, where I'm showing you the real value we presented to the company, and we can put aside hurt feelings over a particular conversation or whatever. Professionals ought to be able to navigate that and make a good financial decision for the company based on the numbers. So I guess my point here is there are going to sometimes be chafing points with an assistant CLO, because the job there is to provide a new perspective, not to just rubber stamp everything the CLO wants, but to be a valuable second set of eyes, ears, hands, and a second brain. Where you don't want to be, where you don't want to always provide a second set of something is the mouth. At least not to, in a subordinate facing way, or, you don't want the assistant CLO running their mouth to the CLO's direct reports or even to other members of the leadership team, other parts of the client. Unless the CLO has specifically requested and authorized that, like, hey, we want you here to provide extra accountability because that's part of our corporate culture. That I would actually really respect. Never seen it yet, but would really respect that, right? Typically, the only person that the assistant CLO is really talking to a lot, in terms of candid feedback, is the CLO themselves, right? So that should be the only opportunity for there to be a chafing point. And those communications should always be respectful and professional and constructive. But sometimes you do have to say things that the other person doesn't want to hear. And that's just being candid, being constructive. When you have this assistant CLO, you strengthen both your strategy and your execution. You see things, from more than one perspective. So there's diversity of thought, which is very valuable. You get a lot of strategic depth, and that leads to new growth. You also enhance optimization. Again, a different perspective. More brains are better than fewer brains, and you get improved workflows because you're seeing things and you're carrying things out in not only different ways, but like more times, and iterate. There's quantity has a quality all its own. So this is actually also an extremely valuable thing. So what do? You say, oh, this all sounds good. I would like to think about a fractional CLO. One of these use cases that you've mentioned appeals to me, and I would like to have a consultation. What would that take? Well, I do offer free consultations, so it's pretty easy. You can schedule a free diagnostic consult, and what we'll do is talk about your need, talk about the use case, talk about the size of your company, whether or not it's likely to be a good fit. And then we probably need to have a conversation as well with the other stakeholders, all the other people, involved in making that decision. The actual engagement process is easy. You sign a contract, you pay for the initial term. Our initial term for our contract is 3 months. We don't offer a month-to-month option because, especially in the initial term, you do need some time to get used to using this service. And we do offer some really cool um, guidance. So we have like courses that are on demand. You're going to do at your own pace that we've developed to teach our clients how to get the most out of the service. So that's pretty exciting. We will train you to use the service. We'll coach you to use the service. We don't expect you to understand right away how to get the most out of profit from legal, because even someone who has like an MBA, they've taken a business law class, um, someone who might think they know how to use a lawyer, they usually don't. And that's not, I'm not trying to be smug or condescending. It's experience. It's just the experience talking. So we don't want to condescend to anyone. We don't want to talk down to anyone, but we do want to provide you with something that you don't have, that you need, that you should have. We want to lean in and listen, look at what you're doing and how you're doing it, and then offer you a better way. I recently had a client that brought me several contracts, and the initial phase, during the initial term of our agreement, we looked at, all the contracts they were using in their business. One of them, needed to be improved. And I actually, even though my role is strategic legal advice, I took a crack at redrafting the master service agreement. And I said, look, you don't have to use this, but here's how I would have written this. And here's also a statement of work that you can use for all your deals under this service agreement. And you can either modify it or you can synthesize it with what you've already got. Before you implement it, please run that by me for review. But here's what I would do, right? I'm just the service provider. Ultimately, the responsibility for the business lies with you. It's a pretty small business, growing, but small. Very limited number of decision makers in the business. So I did that, and then we talked about the way they've structured certain transactions. And I said to them, this transaction, this particular type of transaction you're engaging in, it actually is not that type of a transaction. It's this one over here that's frequently confused. You're using a lot of this terminology and you're kind of trying to shoehorn what you're doing into this other way of understanding what you're doing. That's not there. It's not quite consistent. There's not quite harmony here. When you analyze all the relevant factors on balance, functionally and effectively, this type of a deal is actually this other thing. It has a completely different name. It's a slightly different, but definitely distinct, different understanding of a type of transaction. And you need to comply with regulations. If you're going to continue to do things the way you've been doing it, you need to, make sure that you're fully in compliance. I don't know if you are or if you're not. We'll have to look at that. But here's the thing. I got a lot of pushback from the client. They did not like that, did not want that. And that's understandable because they're used to thinking about things in the way that they think about them. They're used to understanding, well, I have this regulatory compliance burden instead of that one. And they're all tooled up to do things the way that they've been doing it and think about things the way they've been thinking about it. And so they're very attached to the status quo. And that's fine until there's a problem. It's fine until an angry vendor or an angry customer or somebody, really takes a close look at what you're doing and has an axe to grind and hires a lawyer to sue you, to file a regulatory compliance complaint against you, whatever, right? It's you don't realize that you have a problem until it's too late. At the point where somebody's pissed off and they want to do something about it, and they have an axe to grind, they're going to be looking for anything that they can get to call you out on, to make trouble for you. And we see this all the time, all the time. And it's not just it's like the really intense version of a bad online review. It's not just a 1 star or 2 star review on Google. It's, referral to the department of whatever, and then the department of whatever is saying, "Hey, Department of Justice, we've got one for you." And then suddenly, it's the DOJ or the state attorney general or whoever cracking down on your business, and then you've really got a problem. Or hey, Treasury, and there's an audit. You know, so you don't want that. You don't want to get there. And if you do have someone, an employee, a vendor, a customer, somebody who has an axe to grind with you, and they go and they file a complaint like that, you want to come out on the other end of that squeaky clean. You want to come out on the other end of that, like, "Oh, well, yeah, I see why you filed this complaint, but it turns out they weren't doing anything wrong." And the way you get there is to have the right strategic legal counsel. You got to have the right legal strategy. You have to actually understand the structure of the deal that you want to do, and then how to get that done the right way. And I've seen good businesses, honest folks, who are really trying. They're making a good faith effort to get it done. They go and they hire the lawyer to write them the contract. The lawyer does write the contract, and the contract's not bad for what it is. But the problem is that what the contract is and what they're calling the deal is not what the deal actually is. Where the lawyer they hired screwed up, and it's not even a screw up, hardly, maybe, debatably, right? But where the deficiency in their legal support is that the lawyer simply accepted everything the client told them. They didn't look at it really closely. They didn't analyze they didn't take the time, because they're charging by the hour and that's expensive, right? They didn't take the time to interview the client, sit down with the client, talk to the client, consult with the client, listen to the client, ask probing questions, follow-up questions, uncomfortable questions. They didn't do all of that to determine what is actually going on here. What actually is this deal? Well, how is that happening? What happens next? They don't integrate their understanding with the actual operations of the business. And because they're kind of surface level and they're just listening to what the client asks for and responding to that request kind of at a surface level, I don't want to say superficially, that has a whole other connotation, but they're not like diving deep, right? They're taking what sounds like a reasonable request from the client, and they're giving the client what they asked for and what they paid for. There's nothing really wrong with that, except that it's not really what the client needs. Because if we're fair, the client doesn't really know what they need. They know what they want or what they think they want. And I don't want to infantilize them. I don't want to say it's like a child asking for candy for dinner and the parent saying, "No, eat your vegetables." It's not quite on that level, but it's not that either. It's more like, hey, I don't want to stop to eat, and I think I should just be able to drink a meal replacement shake for every meal. Okay. Does it have all the proteins, vitamins, and minerals and all the things you need? Could you live on that? Sure. Is your body really designed for that though? No, like from the time that you're no longer an infant, you're not built to survive on a liquid diet. Your body is built to process solid food as an adult. Can you live on just drinking all your meals? Probably but it may not, there may be unintended consequences there, right? You may have some digestive problems. Just saying. In a similar way, what people want and what's best for them are not always the same thing. Sometimes you need a specialist or an expert or a guru or a Sherpa or a guide or someone with experience to come in and tell you, "Hey, I understand that's what you want, and I understand why you want that. You're not far off, and that's cool. But what you really need is this over here. It's the difference between going to the hardware store and buying that little piece that you think you need for whatever your home improvement project is, and then getting it home and it being like almost, and then you just kind of force it and it's a kludge and it looks ugly, but it kind of gets the job done. And so you kind of laugh it off and you're like, whatever. Versus a contractor going to your DIY project, looking at it and going, I know exactly how to fix that because I've done that a million times. They go to the hardware store, get the right piece, come in, perfectly install it, and it's excellent. That's the difference. You can DIY your legal, but you're going to get a crappy, ugly, sometimes borderline functional, if at all functional result. It's going to look like a kludge. You don't need a legal kludge. You need a beautiful, elegant, functional legal strategy implemented well. And when you do that, you can profit from legal. You can profit from your relationship with your lawyer, but it might require you to build a team. And if you're a growth stage company, you should be doing that anyway. It's going to require you to have, no attachment to the billable hour. It's going to require you to budget for your legal support. It's going to require you to understand and appreciate the role that strategic legal advice plays in the process of providing legal support to your business. Strategic legal advice matters. And it can't just be offered by any old lawyer. And general counsel, legal implementation also matters. And the person doing the strategic legal advice and the person implementing that advice may need to be different people for real and valid reasons, right? It's not just an extra cost. They do different things. Like you wouldn't get mad that you can't just use a hammer for every job. Sometimes you need a screwdriver, and you wouldn't get mad that you have to have more than one kind of screwdriver. Sometimes you need a Phillips head, sometimes you need a flathead. Sometimes you need one of those little weird star doohickeys, right? Use the right tool for the job. I know I just called lawyers a bunch of tools, but everybody loves a good lawyer joke, right? But use the right tool for the job. Strategic CLO is a complete and total game changer for your business. Having strategic chief legal officer, like strategic legal advisory work in your business, total game changer. It will elevate and update and enhance how you support your business with legal support. And done right, it can make your business more profitable and more valuable, more efficient, and less risky to operate. What's not to love? Thanks for watching. I really appreciate you. Go to our channel on YouTube, just search for Counsel and Clarity on YouTube. And if you will, please give us a like and subscribe. Click the little bell button there so that you're notified whenever there are new episodes of this. It's been about 3 weeks since I've done an episode of the Strategic CLO. I had that big transition episode when we were going from the group coaching to doing this instead. And then I had a whole flurry of activity in my personal and professional life that kept me from recording episodes for a couple of weeks. But my intention is to get back in the swing of things and keep doing this regularly, pushing forward, getting information out there. And it's been a real pleasure to take a little extra time with you today, almost an hour and a half, to talk about the need and the cost and how to handle the need and the cost questions, but also to talk about the very specific use cases for how to implement this in your business and what the strategic legal officer, the chief legal officer's strategic CLO would be doing for you. And like all the different ways that they can even work with your existing lawyer. I do hope people understand we're not here to replace your lawyer. If you've got a lawyer in your business, awesome. We want to know how they're doing, not for the purpose of replacing them, but for the purpose of supporting them. If you take a good look at your relationship with your lawyer and you see there's room for improvement, we can be a part of that improvement, not in a critical way or in a way that where we're coming in and like a consultant, with an axe and heads are going to roll. It's not about that. It really is about a really cooperative and collaborative approach to streamlining and improving overall the quality of your legal support in your business. So I hope that people see that. I hope they understand that. And I hope they embrace this new way of thinking about chief legal officers. Um, I don't even think that a company that has an existing chief legal officer, I don't think they should look at profit from legal and what we're doing at IBL. I don't think they should look at that as an alternative to their existing CLO. I don't think that they should say, oh, well, we're paying this guy too much. Let's fire him and hire someone at a third of the cost. And the reason for that, I want to make this really, really clear because it's something that people naturally and reasonably would be worried about. I'm not advocating for a change in overall legal spend. If you're spending $350,000 to have a legal department of one, I'm not advocating that you fire that guy or gal, right? Hire someone who's a third of the cost and keep the difference. Because if you're spending $350,000 on a strategic CLO, the only big change that, I mean, it's just how your money would be spent, right? Like that would be the only change. If you fired that CLO and you hired a fractional CLO instead, you would spend the difference in what you were spending before and what you're spending now on legal implementation, on execution. So, but I think if you've built up your legal support team to the point where you have someone on staff full time at $350,000 a year, odds are that's not going to be your whole. Oh, sorry, I just kind of kicked the thing. That's not going to be your whole legal spend. You probably also have contract attorneys and an associate or paralegal or something like that. You probably also have other people who are supporting that lawyer in your business. I think it would be an extremely rare case to just have like your whole legal department be one guy, chief legal officer, and you're paying him $350K a year. I think that would be super rare. Also, I would struggle to imagine, like I'm struggling to even imagine that in the situation where the guy is not completely overwhelmed. So if that is your legal spend and that is your situation, you're probably not spending enough on legal. You probably need to take another look at your budget and you probably need to see how you can get that guy some support. And our fractional CLO, like I said in the use case presentation, when we were looking at the different use cases, I think it was no, it wasn't this guy. It was this one. Yeah. Oh, no, not that either. Oh gosh, where's my slide? Here it is. The implementation coach, right? That guy's probably so overwhelmed with just strategy and trying to get it all done that he probably needs some help getting stuff implemented, right? So that's probably where you're at if you're in that situation. But it's hard to imagine people even being in that situation at all. It's hard to imagine because you would before you even get there with like an outside general counsel, you would need additional support, I would think. That's just me. But I always love hearing feedback. And if I'm wrong about any of this, please tell me. I'm very receptive to it. Please tell me nicely because I do have feelings and I'm a human. I think sometimes we forget that on the internet. So, um, please be nice about it and just know that I don't consider any of this stuff that I'm sharing to be the final word on any of these topics or any topic. It's a good starting place and it's a good place to start the conversation. And it is based on real experience, like what I've seen work or not work. And so I think it has value and it has merit because it comes from testing. But that doesn't mean like I don't have all the experience in the world. So, I'm in my 40s. I've been doing this for over a decade. I've been doing it successfully. It's gotten great results for my clients. I've saved them millions of dollars, but I'm always open to learning more. So if you want to talk about this in the comments, or if you have a podcast and you'd like to have me on your podcast to talk about this, we can talk about it more. Or if you've got a TV show or a radio program and you're interested in these ideas, I'd love to talk about them with more people. The name of the game for me is raising awareness, letting people know that this is an option, because I genuinely believe that if we spread the subscription model around, right? Like if we all adopt this more for growth stage companies, it can really change the way law firms, and especially like small to medium sized law firms, support small businesses, growth stage companies. This is a model that's scalable. It's scalable up, it's scalable down. So it can even support startups. And I've supported a lot of startups with a model that's very close to this. It's a little more, it's a little less feature rich, I'd say, than our profit from legal service, the one that's scaled down for startups. But that's what they need. They don't need all the things that profit from legal offers, and they don't need to pay that much either. So we can scale this down. But generally, what I'm passionate about is serving the growth stage businesses this way, according to this model, because it works really well. It's the right fit for their budget. It's the right fit for service delivery, and it gets really amazing results. And that's just great to see. So if you're curious about that, if you're interested in that, if you want to talk to me about it, in front of an audience, or if you want to talk to me about it for your company, I'm pretty easy to get a hold of. You can go to counselandclarity.com or go to ibl.law and reach out to me, and I will be responsive. We'll get free legal consultation. Absolutely. Happy to talk to you. It's not going to cost you anything to get the diagnostic consultation. So reach out, talk to me, give me your feedback about this video, or hit me with questions about anything that wasn't completely clear. And I'll look forward to talking to you then. Thanks for tuning in. Again, like and subscribe. I do go live on Instagram and LinkedIn, Facebook, and YouTube all at the same time. So hit me through any of those channels where you're seeing this video. But I'd like for you, if you don't mind, to like and subscribe to the one on YouTube primarily, because that's where I would like to focus the lion's share of my efforts. And if you want to leave a comment on the YouTube video, that'll probably get the fastest response. But thanks again for tuning in. We're at almost right at an hour and a half, which I think is good. So I'm going to end it here, and we will see you next week. Thank you so much.